Thank you for joining us today for the Federalist Society's luncheon today, brought to you by the Capitol Hill chapter as well as the Regulatory Transparency Project. Today's program is called Federal Agencies 101, The Fundamentals. The goal was to take some of the country's top experts and provide some of the fundamentals to those who work on the Hill, who are overworked and have big portfolios, as well as those who are interested as well. My name is Steve Schaefer, and I'm the director of the Regulatory Transparency Project. I wanted to thank the Director of External Relations, Savannah Griesinger, and her team, and also Marie Blanchard, who's on my team as well. After the discussion, there will be an opportunity to ask our experts questions. Just a friendly reminder that the questions end in question marks and are not Shakespearean soliloquies. We have a lot of smart people in this town, but this is a great opportunity to learn from our experts. So, note, all expressions of opinion are those of our panelists. This is a fantastic panel. Just to get to the discussion, I'll keep the introductions short. We're thrilled to have with us Roger Nober, who is the director of the GW Regulatory Studies Center and is a professor of practice at the Trachtenberg School at George Washington University. His career includes service as Executive Vice President and Chief Legal Officer at BNSF Railway, Chairman of the U.S. Surface Transportation Board, and Chief Counsel of the Committee on Transportation and Infrastructure at the U.S. House of Representatives. We are also thrilled to have with us the Honorable Paul J. Ray, who is the Director of the Thomas A. Rowe Institute for Economic Policy Studies at the Heritage Foundation. He also served as the Administrator of the Office of Information and Regulatory Affairs, also known as the Regulations Czar, within the White House Office of Management and Budget. He also served as counselor of the to the U.S. Secretary of Labor, and he also has experience in private practice as well. Just really honored to have with us our moderator today, Jane Luxton, who's managing partner at the Washington, D.C. office of Louis Brisbois. From 2007 to 2009, she served as general counsel of the National Oceanic and Atmospheric Administration. She also has served as first chair in prosecutions of antitrust and other criminal cases at the U.S. Department of Justice, as well as the U.S. Attorney's Office. Jane, I'll turn it over to you. Thank you.
Is that on? It's on. Thank you, Steve, for the kind introduction. And let me add my welcome to Steve's. Delighted you're here. This is a topic that is near and dear to all of our hearts. And hopefully it's one that you've wondered about, and we can answer some of your questions, and then you'll have a chance later on to ask us some more. I think we should just jump right into it. Unfortunately, one of our speakers was unable to be here. His plane developed mechanical problems in New York and then was canceled. But between the three of us...
Before it took off.
Yes. Good point. Among the three of us, I think we can cover the waterfront pretty well. So let's start off with you, Paul. You were going to address... First, the authority for rulemaking, and also go into what Boris was going to cover on how rulemaking works.
Well, I'll just make it unanimous and say join Steve and Jane in saying thank you for being here. Great to be here with you today. Do you guys hear that buzzing? Yeah. All right. We'll just do the best we can. So how many of you are lawyers? A number of you. How many of you have, a number of you, of course, are on the Hill. How many of you have been at agencies as well? A fair number? Okay. Good, helpful for context. So, okay, so
I would just add, how many of you want to be lawyers? So we have
you can answer that question whether you are a lawyer now or not. Yeah, I just want to give a brief overview, really tailored to those who don't have administrative law experience, of the way the the regulatory process works. Of course, I'm going to leave questions about adjudication to Roger, who actually knows about things like that, as I do not. Hopefully you all know that agencies regulate because they are given authority to do so by Congress. Every regulation begins with a statute, and statutes come from Congress. We all know that. Congress delegates, or has delegated over the course of the last century, a vast number of authorities. And it does so in a couple of ways. The most obvious is an explicit delegation, so a provision in a statute that either directs or empowers an agency to issue regulations on a particular topic. Quite common way to delegate. Another way to delegate is what we could call implicit delegation. So under governing case law, an agency is implicitly typically taken to have authority to regulate when there are terms to be filled in a program that it administers, statutory terms to be defined, and also when there are procedures that are needed or other implementing details needed in a program the agency administers, even if Congress has not specifically directed or empowered the agency to regulate. So that's how regulation gets its start. Now, almost every regulation is issued under the Administrative Procedure Act. There are a few exceptions, but we don't need to get into those. The process for issuing a regulation under the Administrative Procedure Act is quite simple in its form. There are two main stages, typically. There's the proposal and the final regulation. The agency, perhaps in response to the agency's own initiative or an initiative from the White House or a request for rulemaking from the public, deliberates internally about what a sensible regulation on a particular topic would be, and then it submits a draft of the regulation along with underlying analysis to OIRA for review. How many of you have heard about OIRA before this lunch? See, this is a sign you're in Washington, right? that kind of response. In other places, the response is about 1%, if that. OIRA reviews, and we'll talk about OIRA review later. OIRA reviews the regulation and runs the interagency review process for the regulation, and then after OIRA has signed off, the author agency proposes the regulation in the Federal Register. Public submits comments. On an important proposal, there could be millions of comments. More typically, there's a few thousand or a few hundred comments. The agency then evaluates the comments, makes any changes to the proposal that it needs to, and then submits a final regulation to OIRA for review. OIRA reviews the regulation, goes through the same process it did for the proposal, and then the agency finalizes the regulation, which is typically effective some 30 to 60 days after issuance. And then, of course, there could be litigation about the validity of the regulation immediately afterwards. Yeah, I guess I was going to go into OIRA review, but I'm going to pause there and come to that later.
Paul, can I just throw in another thought or two? There is also, in some cases, an advance notice of proposed rulemaking, which is not a formal part under the APA, but sometimes an agency is trying to get a sense of a particular problem and how people might want them to try and solve it. So the agency can put it out for comment, doesn't have the same formal requirements as a proposed or final rule, and does not go through a OIRA review. It's more of an informal suggestion box kind of thing. And so they can use that to draw out comments in an early stage of the rulemaking. It's very important to pay attention to that because the earlier you can get in and try to affect how a rule is written, the better. It's not yet gelled into a final form, so ANPRMs can be very helpful with that.
That's right. I'll second that, and even less formal is a request for information, or RFI. You may be familiar with those. Jane's observation about participating early in the process is exactly right. By the time an agency has has drafted an NPRM, a Notice of Proposed Rulemaking, in a major proceeding, it's already put in a lot of thought about the appropriate policy stance to take. And so agencies absolutely do revisit those decisions in response to comments and other kinds of input. But if your first time engaging the agency is after the NPRM is issued, really you're sort of already on the back foot, at least in a major proceeding. Great. Roger, do you want to take up the adjudication question?
Turn to adjudication. Okay, so adjudicate now in the overall dealing with. Let me turn my mic on. Okay, well, again, after I get over my own technical difficulties, I want every meeting I do to be like a Zoom call where I'm on mute until I remember to start, even 4.5 years later. So if we were in a law school and we were learning about administrative law, they would tell you, the professors would say that there are two basic types of administrative law. The first is the public notice and comment rulemaking that Paul was just talking about, which are rules of sort of, you might call a legislative rule, and that is generally applicable. On the other hand, there's a vast number of things that individual stakeholders do with agencies, and for those of you on the Hill probably are asked to be involved in these all the time, whether they are people who are or stakeholders who are seeking permits, approvals, enforcement actions, they apply for a grant, their agencies are doing reviews or oversight, somebody's asking for a waiver, and then there are times when there are like formal adjudications when people go before administrative law judges. But the Administrative Procedures Act governs the way agencies deal with this vast number of actions that they take. And the general principle that the agencies can't be arbitrary and capricious also applies to individual actions. And if you think about it, that makes a lot of sense. You don't want a government agency deciding to act and take, for example, enforcement actions only against those who it believes might be opposing them or political enemies for whatever reason or opponents. On the other hand, you don't want it approving those that are on the favored side. So having general fairness standards apply to the probably 90% of what agencies do that is on the adjudication side makes a lot of sense. But on the other hand, it can be very challenging for stakeholders to go through an adjudication, and many of the process safeguards that Paul talked about in rulemakings that are present are harder to achieve or harder to realize on the adjudication side. The first is that by the Administrative Procedures Act, if the agency takes a formal action, it has to follow precedent. So if it's decided a similar issue before the same way, it has to follow it. And if it wants to deviate from precedent, they have to explain why and give a compelling rationale as to why they were going to change, which means that if the agency decides your competitors or somebody else's similar application a certain way, you can be confident that yours is probably going to go the same way. The second is that your rights of appeal during the process and your rights to challenge it are much different. I won't say more limited, but in the administrative law doctrine under the APA, you can only challenge in court a final agency action. And in the rulemaking context, a final agency action is fairly clear. And what the agencies have to do is they have to evaluate and answer comments, and they respond to them and explain why they may or may not be following different comments. In the adjudication context, that is much more nebulous. So, agencies all the time can make what might be an outcome determinative decision on a permit application or on an enforcement action. And only until the final judgment is rendered do you have an opportunity to challenge or enforce that. So that may be one reason why stakeholders might come to congressional offices and ask them to weigh in, because they're trying to influence an interim decision that is otherwise not challengeable. Then, at the same time, there's the challenge that you're usually on your own as a stakeholder in an adjudication. It's rare that you have the protection, if you will, of trade associations, of national NGOs who might be interested in your matter. And instead, because often for competitive reasons, you'll find that other similarly situated stakeholders will generally be reluctant to get involved because it might be involving, for example, if it's a drug approval, sensitive technology or confidential information. If it's a merger, for example, the Federal Trade Commission may or may not decide to get comments from other similarly situated stakeholders. So there's just, and if it's regulation or over, let's say the National Labor Relations Board or the Fair Labor Standards Act, NLRB want to come and investigate employment practices, typically you won't find competitors, even if they do similar actions, weighing in on those. Sometimes they do, but mostly they don't. So adjudications are when you sort of walk through DC and you see all of those buildings of those giant law firms and say, what do all those lawyers do? They are typically working with stakeholders on dealing and approaching agencies and trying to solve this sort of vast number of problems. And it's one where stakeholders have to develop relationships with their regulators, and they're people that they have to deal with time and again. So challenging those actions is something that comes with a lot of caution and thought. And secondly, there's a lot of ways that agencies can signal what they're going to do without ever making an actual decision at all. So agencies will put out guidances, they'll put out policy statements, they may just make a speech. And if the head of an agency makes a speech and says, we are not going to approve any application for X, is somebody going to then turn around and bring one and force the agency to rule on it, turn it down, and then appeal it and go to court? So very often agencies can basically effectuate a great deal of policy through how they choose to adjudicate and how they choose to deal with different stakeholders. So we could talk the rest of the hour about different examples and different times that we've tried to do this, but again, I would venture that when, at least in my time on Capitol Hill, when stakeholders would come in, very often it was to ask members of Congress, their offices, to weigh in on any one of these things, grant applications, the different individual adjudications to try to influence the agency, and that's for better or for worse one of the more effective ways of being able to do that. So with that, I'll stop there. And
yeah, Roger, let me just ask a question about the ex parte rules for adjudications.
So ex parte rules are what they come up as, and the question is, are you allowed to talk to agencies about substantive matters when there's a formal proceeding pending, and if you do, how are those able to be handled? Can the agency do it or not? And typically, the sort of stock answer is, if you have a formal proceeding, agencies are not allowed to engage in ex parte communications. But there's an awful lot of gray area around when is an actual proceeding pending. And so is it a formal adjudication, or very often what stakeholders will do to get around that, the prohibition on ex parte communications, is go in and have an informal meeting with agency people and say, what would you think of X? Right? That happens. Jane, you probably do that on a if not daily basis,
once or twice.
Once or twice, people have done that.
Yeah,
and so that's one way you would handle it. Another one would be to say that, for example, in the rulemaking context, you can have ex parte communications. They have to be documented in the record. That's another way of curing it is the agency. Agencies typically don't like to say that they met with applicants and put that in the public record, but you can cure them with disclosure. So there's a lot of the strategy of dealing with your agency works around how to address the prohibition on ex parte communications, or if not, whether or not you want there to be disclosure about them. So that's an excellent question, and
an excellent answer.
Something that gets a lot of thought.
Yeah. Okay, well, we have some questions for the panel that we're going to run through quickly, and in order to leave time for questions from all of you. But first question, Roger's already started down this path, but how can members of Congress and staff effectively engage with the regulatory agency adjudicative process? And I'm just going to add, or rulemaking process to that.
Well, I'll take up the rulemaking part of the question. So, really, there's three ways that you can you or your members can engage. One is through the commenting process. So, members, like any member of the public, can write a comment to the agency. And we can talk later, if folks want to, about what goes into an effective comment. Of course, members can also engage informally. They can have conversations with the agency. If a member wants to have a conversation with an agency during the pendency of a rulemaking proceeding, then typically that meeting will have to be through the OIRA 12866 meeting process, which we can talk about in a bit. But basically, it would be a meeting on the record. Even members of Congress have to go through the OIRA process. Of course, a more flexible and probably more effective means of intervention would be to for the member to meet with the agency before a proposal is issued. And then, of course, members of Congress, unlike members of the public, can make laws. At least so I'm told. There are different ways members of Congress can affect the regulatory process or regulatory outcomes through legislation. One, of course, would be an act that forbids or requires a certain outcome in a regulatory proceeding. You could change the law, right? Members of Congress can attach appropriations riders forbidding the use of funds for particular kinds of proceedings. That's not an uncommon thing that I've seen. Many agencies are working under various appropriations riders that forbid work on certain kinds of regulations. And then, of course, there could be action under the Congressional Review Act. Now, the Congressional Review Act creates an expedited process in the House and Senate for Congress to disapprove a regulation. If both houses enact approvals of disapproval, resolutions of disapproval. That's why it didn't sound quite right. Resolutions of disapproval. Then the regulation is invalid. If the president signs the joint resolution, and that's the kicker, of course, a president is highly, highly unlikely to sign a joint resolution invalidating a regulation issued by one of his agencies. Not impossible, but highly unlikely. So the utility of the Congressional Review Act really has to do just with regulations issued in toward the end of a presidential administration, in which Congress might enact a joint resolution that is then signed by the succeeding president. So basically, what that means is that regulations that are enacted, it's 60 legislative days before the end of a presidential term, fall within what we call the CRA window. That is to say, the period in which the joint resolution could go to the desk of a new president for signature. When exactly the window opens depends on how many legislative days there are in the last year of a presidential administration.
Which is something surprisingly difficult to calculate, and our center has spent a long time looking at that. I would say on the adjudication front, many similar kinds of ways are effective. Now, I'm guessing anyone who works for a member's office or a senator's office has been asked to sign a letter supporting a grant application of some kind, right? And that's a very common thing to do. So members can support individual applications on the record by filing a formal letter, and there may be political reasons why folks want to do that, to be seen as supporting the State Department of Transportation's application for bridge funding, for example, or for a new metro line. There may be that you may be asked to weigh in informally, as Paul mentioned, to talk to the agency, either before a matter is pending or if it's pending. Then it can be very subjective as to whether a call from a member's office saying, let's say that you have an enforcement action, or there's a permit that's pending. Say, you have to evaluate. They call the agency and say, you have to evaluate this on the merits. But from what I know, I think it's a very valuable application that they're making, and you just decide what you want to do with it. And of course, the agency gets off the phone and says, okay, I got what that meant, even though they weren't actually asking them to do anything. That's another very common tactic to avoid and get around disclosure. And so I think that agencies are quite cognizant of legislative interest in matters, and that is probably why so many stakeholders ask you to come in and get involved in individual matters, because they know that's an advocacy strategy that can work, and that the agencies will pay attention to. They may not follow it, but it certainly will get the attention of the agency. So I think, and obviously, people can ask you to do, and I don't need to tell anybody in this room this, a lot of crazy things, and you obviously don't want to get involved and just react to everything everybody asks you to do, which I know is manifestly obvious, because sometimes you'll have to make a judgment as to when to do it. But the reason people ask is that is one of the more effective ways of getting through to an agency.
So I should add, with respect to interventions in rulemakings, and Roger, I defer to you on the extent to which this is true, if at all, for adjudications. A lot of people have a conception, a very understandable conception, that to intervene in a rulemaking means you need to talk to the agency in some way. And that is, of course, one way to intervene in a rulemaking, but there are other ways. The reason there are other ways is because a rulemaking, really any important rulemaking, is a whole of government exercise. OIRA, in addition to reviewing regulations from the agencies, also circulates those regulations to other agencies and offices in the White House for review. And so any important regulation is going to have to have gone through a process involving participation by the Domestic Policy Council, the White House Counsel's Office, the National Economic Council, the Department of Justice, and any other agency that has what in an executive branch speak we call equities, right? Mm-hmm. So, regulations under the Affordable Care Act would typically be reviewed by the Department of Labor, Treasury, and HHS, and maybe other agencies as well. It's very, very common for many agencies and White House offices to review an important rulemaking. Any of the reviewers can affect the content of a final regulation, and so so engagement with any of the reviewers can be helpful. It can make a lot of sense to talk not just to the author agency, but to the White House offices that you think are going to be involved in reviewing the regulation, and also sister agencies of the author agency as well. So I'd really urge all of you to consider, when advising your members about how to engage, the fact that there are multiple points of entry into the regulatory process. I'll stop there.
And I'll just add a couple additional thoughts. Exactly what Paul and Roger have been talking about. When a congressional staff member or the staff feels strongly about a particular issue, if they write a comment, it's part of the administrative record, and we probably need to cover this point because in challenging a final agency action, that challenge must be based on the four corners of the administrative record. That means everything that was before the agency at the time it decided. The point is, you can't, after the fact, come up with some new thing unless you file a petition for rulemaking to start over again. But all of these comments that go into the record, including those of other agencies, it takes a lot for them to get permission to do this. But the Small Business Administration Office of Advocacy has a mission to protect small businesses. So it is not uncommon at all for that office to file comments on the record. And what they are doing is assisting people who will challenge that rule by saying, here's a federal agency that said this will have an undue adverse effect on small businesses. Or if you have a staff member saying this isn't what the legislative history or congressional intent was, all of that can be useful in filing an appeal. The other thing I wanted to mention, Paul gave a good list of ways to engage, including appropriations and legislation. But in addition, there are oversight hearings that members can convene where they just yell at the agency and pound them. And their objective, of course, is to make them change course. One other tool is a congressional investigation. If there's, typically these are when there's some widespread press reports of some event or a car recall or something. These are spectacles, and they also can be influential in the outcome of a rule. Do you want to cover RFA and PRA?
Sure, I can cover those. I'll talk a little more broadly about analytical requirements. So, if you read the analysis attached to a proposed or final rule, you will find that the agency is offering analysis under a number of statutes and executive orders. There's a number of requirements for analyzing rules in different ways that are contained in law and executive orders. Probably the most significant is the set of requirements in Executive Order 12866, which has been amended many times since it was issued by President Clinton, but as amended has been embraced by every president since then. EU 12866 requires an analysis of benefits and costs and a comparison of the two. For the most important rulemakings, with an estimated impact now of over $200 million, the cost-benefit analysis has to be more detailed and more, well, aspirationally more quantified. So if you're interested in engaging a regulation or engaging a rulemaking, one place to start would be by engaging the agency's estimates of costs and benefits. If you think that the agency has radically underestimated costs or radically overestimated benefits, and you have data to back up that notion, well, you should tell the agency about it. You can really shift the rulemaking in important ways by suggesting that the agency might not be accomplishing the good it thinks it's accomplishing, or that it's going to have a lot of negative side effects if it proceeds on its current path. So EO 12866 is the most important, or contains the most important set of analytic requirements. But there are also requirements under the Regulatory Flexibility Act, which was passed in 1980 to protect small businesses, and the Paperwork Reduction Act, and a few other statutes and executive orders. I'm thinking of the Unfunded Mandates Act, for instance, UMRA. All of these acts together require the agency to make a number of findings. For instance, the Reg Flex Act requires the agency to estimate the number of small businesses that will be affected by the regulation, and if it clears a certain threshold, to basically state the options it considered for lowering the burden on small businesses. There are other requirements that I won't get into here. For your members' purposes, the analyses are most relevant because the agency relies on the findings that it makes pursuant to these executive orders and statutes. And so if you can show that the agency's analysis is lacking in some way, you can change the outcome of the proceeding. So let's say there's an agency that says this regulation will impact very, very few small businesses, and so we have not assessed options for easier compliance by small business. And you can show that actually there'll be 100,000 small businesses affected by this regulation, right? Well, that could be a very consequential fact to point out to the agency. So I know not everyone loves reading regulatory impact analyses as much as I do. I find it hard to believe, but it's true. But I encourage everyone to do so when you're going to engage in a rulemaking.
Yeah, thank you, Mark. The other thing is that those same lines of attack can be useful in a challenge of the rule before the courts. And sometimes if the agency is totally off base, that's the easiest way to get a rule reversed but you need economists and so forth, and you really have to dig into these analyses.
Before you go, I was just going to mention one thing about appeal, and that on appeals, as Paul just went through, there are a number of procedural requirements and substantive requirements that agencies have to put in a rule that you can challenge with data and are applicable in in an appeal before the Court of Appeals. In an adjudication, it's more difficult because you typically don't have generalized requirements like that, and you have an individual record, often very fact-specific, about dealing with an individual stakeholder. And courts have proven to be a little more reluctant to overturn factual findings in the expertise of the agency versus, for example, a generalized, have you done the cost-benefit analysis or review analysis properly? So it's more of an uphill battle for an individual stakeholder to appeal, even though the statute is the same and the overall legal requirements are the same. The ability and the grounds on which to challenge an adjudication are more limited, and the consequence is a little bit different too, because if a rule gets reversed and remanded back to the agency for further proceedings, they may decide to reissue it, they may not. But if it is one of general applicability, if you're an individual who's regulated by an agency and you go to court and it gets overturned, your recourse is to go right back to the very people who ruled against you in the first place and have them redo it. And that's something that stakeholders have to weigh very carefully.
Good point, Roger. Let's take a moment or two and talk about how cabinet and independent agencies are different in terms of the process and effective engagement.
Sure. So I want to begin by saying executive branch and independent agencies are very similar in a lot of ways. That an agency is independent doesn't mean that the president has no influence over it. Usually it means that the president, when we say an agency is independent, usually what we mean is that the president can't fire the agency head except for cause. There are some other indicators of independence, but that's the main one. But of course, it's unusual for a president to fire an agency head anyway. It happens sometimes, but it's unusual. But presidents' voices matter on regulations, even when there's no threat of termination. It's because presidents have all kinds of goods they can offer to agency heads, and usually they've selected the agency heads based in part, at least, on the agency heads' alignment with their own policy vision. So all to say, I think that it's important to realize that executive branch agencies and independent agencies are more similar than you may at first think. But there are some differences. Most important difference is that the independent agencies do not send their regulations to OIRA for review. They do publish a plan of their regulations in the unified agenda, and they do comply with some parts of Executive Order 12866, but they do not send their regulations to OIRA for review. And that matters for several reasons. One, it means that the opportunities to engage in a rulemaking through the multiple points of entry that I mentioned earlier are pretty significantly diminished where independent agency rulemakings are concerned. Sometimes other agencies, including executive branch agencies, are involved in rulemakings by independent commissions, but the touch points tend to be fewer in those rulemakings. So that's one difference to keep in mind.
Roger?
If I could just add to that, at an independent agency, there typically are multiple members, and Paul, the points Paul made are the starting point, right? Which is that it's independent. You don't have the White House OIRA formal process to use as a leverage or as an influence point. At the same time, most agencies will have, independent agencies will have their bipartisan multi-member. So they will have somebody who's a chairman, typically appointed as chairman, not confirmed as chairman. There are some exceptions to that, but most of the time they're appointed, and the chair serves at the pleasure of the president, even though they can't be removed from the agency per se. And so you do have the ability to speak to and try to influence individual members, and again, the same kinds of ex parte communication requirements are a part of that. But that is one way of being able to address them. Another way is that typically, that oftentimes independent agencies will have a set of formal adjudication with an administrative law judge and a quasi or even very, very similar to judicial format that you typically don't see at the cabinet agencies. And there's been a legal challenge to the way the SEC runs some of their enforcement actions. They're an independent agency. You've all read that. Then there are times about how the agency conducts itself becomes an issue. You've read a lot about how the FDIC has gone about things, and so independent agencies are very, I would call them siblings to the cabinet agencies. There are a few differences, so they're not identical. The APA requirements, the Administrative Procedures Act requirements, still apply in the exact same way. One sort of final, I get, maybe it's a little inside baseball, but many independent agencies have what they call independent litigating authority. So they themselves, not the Department of Justice, decide when to defend a rule or perhaps bring an enforcement action or challenge matters in court. So that is from the inside out, that makes a huge difference. I'm not so sure from the outside in it makes a really material one.
So one I want to make. So we've been talking about for some time now about ways to engage agencies. I really do want to say something before we move on from this topic about why you should engage in the rulemaking process. There's a perception sometimes in DC that a notice of proposed rulemaking tells you what the agency is going to do, not what it's thinking about doing. That the agency has made all of the important final decisions by the NPRM stage, and so it might be useful to comment to prepare litigation, but it's not actually going to change the outcome of the regulatory proceeding. I just want to say that's not true. Agencies do pretty regularly make quite important changes between the proposal and the final regulation. I mean, if you want to Exhibit A, just look at the SEC's recent climate disclosure rule. It's a vastly different final rule than the proposal was. Now, it is true that in a high-profile proceeding in which there's been significant White House engagement, there may well be some set of core goals that the agency has really settled on in consultation with the White House. But it's very hard, very, very hard to know what those are from the outside. And almost invariably, there will be room for the agency to change what it proposes in response to comments from the public. So I would just say, do engage in rulemakings. Engagement really can make a very large difference, and not just in preparation for litigation.
Good point. Let's take a quick round on what developments are in play that could change the regulatory agency adjudicative processes. A few cases are before the Supreme Court on this issue.
Yes, that's right. Daily refreshing our news feeds on these. So one important one is, of course, the Loper-Bright case. Many of you may have heard of this one. It tees up the question of whether to overrule the Chevron case from 1984, which established judicial deference to agency interpretations of the provisions of statutes that they administer. That's an important one. The Jarkissi case is another important one, in which the court might breathe new life into the non-delegation doctrine. And then, of course, there was an important CFPB case that the court's already decided about the viability of the funding structure that CFPB operates under. That one's a little more sui generis. It's an unusual funding structure. But Loper-Bright and Jarkissi are certainly two cases to watch.
Roger?
No, obviously what the cases Paul identified are really top of mind and would provide some of the most significant changes in the administrative law process in some time. Remains to be seen how significant they will be in the long run. That's a matter of a great deal of debate. I would say the other thing just to be mindful of, which the Supreme Court cases are involved with, but not the only issue, which is the problem that we're seeing in recent years of regulatory whiplash, where it's so difficult for the legislative body to pass statutes for whatever reason, that agency, when a new administration comes in, the first thing they say is, I'm going to use the pen on day one and use the rulemaking process to do X, Y, or Z. And of course, the underpinning of the debate over Chevron is, and the major questions doctrine that's also out there is, do they really have the power to do those things, and to try to scale back the ability of agencies to say on matters, or new administrations say on matters where Congress has been unable to legislate, I'm just going to regulate. And I do think that many of us are hopeful that we will see less of the whiplash back and forth, and that we will see some, what sometimes the regulatory law experts say, going from the between the 10s to maybe between the 40s, where things stay a little bit more in the middle and stakeholders are not whiplashed back and forth. But it will be interesting to see how this all plays out. If you're a regulatory law expert or geek, as we sometimes say, you can't wait to see how all this will play out. It will certainly be an interesting change.
And I'll just add one more a case I only became aware of recently. The APA does not, inside the four corners of the statute, have a statute of limitations. And the convention has been a 6-year practical statute of limitations based on, that's the time limit in which you can sue the government. However, the case before the Supreme Court this term involved a situation where a company new to a regulation sued, and it has teed up the question of whether there really is a firm statute of limitations under the APA for challenging final agency action. So it's another one to watch. Okay, well, I think we are open for questions from the floor. Yes?
A year or so ago, I thought the Solicitor General's efforts to distinguish a year or so ago in Texas versus United States, the Solicitor General made an effort to get the court to distinguish set aside from vacate. And I think Justice Gorsuch wrote about it in his concurrence in that case. And I was just wondering if after Chevron you see any runway for that issue to get fleshed out at all.
I think of the issues as distinct. You could you could have different remedies regardless of whether Chevron deference is in play in a particular case. So I kind of think of them as just distinct.
Okay. Next, any other questions? Yes, in the orange dress. You.
How does prosecutorial discretion fit in the framework for administrative law?
That is an excellent question, and one where administrative law, the question was, how does prosecutorial discretion fit in the framework of administrative law? And it's a place where I fear that administrative law doesn't really have a good answer to the idea that an agency can create a body of law through what it chooses to enforce against versus what it chooses not to enforce against, and use the APA's requirement that agencies follow their precedents to create a jurisprudence, if you will, of regulation by enforcement. And that it does a few things. The first is that uncertainty becomes a regulatory strategy in and of itself. So if stakeholders don't know what the agency is going to choose to object to and challenge versus not, that is a deterrent in and of itself to taking on either developing new technology, doing a transaction, making an application for something. And it's really very hard to tell an agency where it has discretion to decide whether to challenge something that it should be challenging ones it's not, or it shouldn't be challenging ones that it does. Now, if it decides to exercise its discretion and bring an enforcement action against a certain one, that can be, you can try, the stakeholder can try to argue that it's unfair, but it typically has to be looked at on its own. Another area where you see a great deal of concern about the prosecutorial discretion would be from labor agencies or health agencies like OSHA, which kinds of operations do they choose to enforce labor standards or occupational standards against? And there can be a great deal of latitude in what they do. You can have differences between field offices of the same agency, where some regions will take a much more stringent approach to enforcement actions than other regions will. And there are, unfortunately, there are relatively few protections for the stakeholders in those circumstances, other than to highlight the issue and to begin to, that's a place where members of Congress and Capitol Hill can weigh in on discrepancies and how agencies exercise their discretion. And it's an area of a great deal of interest to me, so I think it's a great question.
Yeah, and members of Congress, if they are concerned enough about it, could certainly use some of the tools that Paul was talking about, especially appropriations, to have a report and rider language saying the agency may not use any of its funds to do X or not to do Y. So that's a tool that would probably come into play, particularly in that kind of situation.
But it's very subjective, though. Just to follow up, how do you protect against that? Because then you have a lot of situations that are out there where you want the agencies to have the ability to investigate problems. I mean, who would not want, if the door flew out of the plane you were on, you wouldn't want the FAA or the NTSB not to be able to investigate what were the reasons for it. And then in other circumstances, you might feel that their discretion was unwisely used. And so it's very, very challenging and difficult to put objective standards around a subjective process.
Other questions? Yes?
This is an ad law question. I seem to recall back from my days in administrative law that the PRA can be challenged up until, failure to follow the PRA can be challenged up until the Supreme Court.
So there's no direct review provision, as in the case can't start out in Supreme Court, but...
But if an agency failed to follow the PRA and a rule went into effect and was in effect for years and years and years, and then someone suddenly discovered it, the agency would be prohibited from enforcing the rule, is my understanding, if they never followed PRA.
There's no control number.
I see, yes,
yeah.
yes. So if there's no control number, then you simply needn't comply, right? You just, yes. Also, PRA applications have to be renewed, granted again every 3 years, right? So, so you don't, yes. So, bottom line is, if there's not a control number, you don't have to comply. And then if there was an error in the PRA process, let's just say it bears a control number, but the PRA application was deficient in some way. Well, then I don't think there's much of a risk of an antiquated error kind of hanging around for forever, because it does have to be reconsidered every 3 years. But you know, there could be, of course, errors in PRA packages that does happen, and the move typically there would be to file a petition with the OMB director in the first instance to have a correction made.
Other questions? Yes?
John Burlaw, Competitive Enterprise Institute, also a member of the Regulatory Transparency Project Finance section, financial regulation. Wanted to ask about as far as whether courts can review like a final agency action, or whether they have, whether they review others, that are not quite at that stage. I believe there's a difference when it's an actual constitutional challenge, because I think starting in Free Enterprise Fund versus PCAOB, Justice Roberts said that agencies don't have really any expertise on the Constitution. So if there's a constitutional problem with a rule, that might be able to be challenged earlier than otherwise, if it's just like an issue of whether they're misinterpreting the law, the statute itself. Can you comment on that?
I was hoping you would take it, Paul.
Interesting question.
But it is an interesting question. I don't know offhand whether or not a constitutional challenge in the course of an adjudication could be made earlier. I just don't know the answer to that. Typically, you have to have a final agency action to challenge the outcome. Now, what if you're arguing is that the process or the underlying regime under which you're being challenged or enforced against or reviewed is unconstitutional, then I have no reason to doubt that. I wish I could give you a definitive answer off the top of my head. I just can't on that one. I have to say that in my 30 some odd years of legal practice in the administrative realm, I've never seen one, but that doesn't mean a constitutional challenge, but that doesn't mean that they don't exist. They do, just one's never come across me.
Did the CFPB issues, that bounced around in the Fifth Circuit and other places, and I have the dim recollection that the constitutional issue having to do with the composition of the director and all that, I think that might have gone up before it was a final agency rule.
And I think that there was something with the SEC's administrative law judges as well.
Yeah.
I think that one also has happened.
Bypassed.
Although I don't know if that was after a final agency action or not.
But there are also regulatory takings.
Yeah.
For an agency took a regulatory action and was deemed a taking.
Yes, although I think those are after the agencies acted.
Yeah, like the
But the zoning
EPA,
cases and stuff
I'm
that
thinking
you're
of the
thinking
EPA
of.
takings cases on water rights, watersheds, I can't remember. Yeah. Any other questions to stump the panel?
I'll just say on a final agency action, one of the most frustrating and difficult to address issues is when an agency simply fails to ever finally decide something. Mm-hmm. And so some of the takings and permittings cases that folks were just referring to, Jane and Brian were referring to, could be 15 years of process where the agency's never given a final decision, and that the administrative law process and the appellate process is not really solved if an agency just chooses to never give you a final action how to deal with that yet. It can be ever hopeful, but
yeah. Another question that might come up is how difficult it is to try to bring a mandamus action against an agency for not acting, particularly when you filed a petition for rulemaking and you want the agency to rule up or down so you can challenge it if they don't go the way you want, and they just let it sit there. And so often I am asked by clients, how long can they have? And, it's really hard to answer. There's not a lot of positive case law on this, and the answer is they can wait a really long time before you'd be able to bring an action like that. Is this our time?
Well, please join me in thanking this fantastic panel for this outstanding discussion. And I wanted to thank all of you for joining us today. For more content that involves Congress and Article 1, please check out fedsoc.org. That's fedsoc.org, and look at what the Capitol Hill chapter is doing. And for more regulatory state programming, check out regproject.org. That's regproject.org. Thank you.